Good morning, everybody. My name is Brian Beamish. I'm the Information and Privacy Commissioner for the province of Ontario. And I would like to, on behalf of our office, welcome everyone for showing up this morning. I want to thank you for attending. Really good turnout. I understand we have over 280 people signed up to watch us on webcast. Welcome to our annual Privacy Day event. January 28th has been recognized as International Privacy Day or International Data Protection Day for a number of years now. And in addition to the event we're hosting today, there will be events across Canada and in other countries across the world. These events are to mark the importance of privacy in our everyday lives. The IPC has traditionally held an event to mark International Privacy Day. Last year, we focused on the importance of health privacy and protecting electronic health records from inappropriate access. But the event is designed to focus attention on an issue of importance to the citizens of the province. This year, we're really pleased to be focusing on the interplay between the legitimate needs of the law enforcement and public safety community and how that impacts on the importance of personal privacy. I think all of us recognize that law enforcement has legitimate needs to collect, disclose, and share information. However, that has to be done with a respect to privacy and within legislated limits. This is an area that our office has been involved in for quite a while, but I would say in the last year we've seen an acceleration of the issues that we've been involved in, where we have this interplay and connection between public safety needs on one hand and the need to protect legitimate privacy interests on the other hand. Now you're going to hear in a few moments from our excellent panel who will explore this issue. David Goodis, our Assistant Commissioner, will introduce them at the start of the panel, but I'd like to personally thank them for participating and recognize their presence today. We have Brian Larkin, who's the Chief of Waterloo Regional Police, Renu Madani, the Chief Commissioner with the Ontario Human Rights Commission, Matt Turigian, the Deputy Minister from the Ministry of Community Safety and Correctional Services, and Michael McAvoy, who's the Deputy Commissioner with our good friends and colleagues at the BC Information and Privacy Commissioner's Office. Four outstanding individuals who are going to bring some, I know, some interesting views on these issues for our consideration. Before the panel, though, I would like to spend a few minutes and talk about the views of our office and our activity in this area and how we see this, how legitimate law enforcement needs can be conducted in a manner that's respectful of individual privacy. If there's a theme here from my experience, and particularly the experience of our office over the past year, is that the needs of law enforcement and public safety can be accommodated in a manner that does respect the individual privacy. That there is a lot of common ground here, that all the actors in this area have similar interests that can be accommodated. And if the individuals involved in these issues are collaborative, approach these issues with goodwill in a manner to seek resolutions, we can really affect change, and we can do it in a manner that does respect individuals' privacy. Let me start giving you, just before I get into some specific issues, giving you a little bit of background into our office and some context. Our office is responsible for the oversight of 3 pieces of legislation. Of particular interest for today is the Provincial Freedom of Information and Protection of Privacy Act and the municipal equivalent. Both these pieces of legislation set out the rules for the collection, use, and disclosure of personal information for government organizations, including, of note, police services. For example, the activities of the Ontario Provincial Police are regulated under the Provincial Freedom of Information and Protection of Privacy Act. Municipal police services fall under the ambit of the Municipal Act. Both of these acts are designed to protect individual citizens' right to informational privacy. However, they do contain special latitude and special considerations for law enforcement, recognizing that law enforcement activities may require additional freedom in terms of the collection, use, and disclosure of personal information. However, that activity has to take place within the ambit of the legislation, and those law enforcement activities also have to be consistent with charter rights. And we've had now a series of consistent court cases that have made this point, the importance of law enforcement activities being conducted in accordance with the Charter. I've put up a quote from a recent Supreme Court of Canada case. Justice Karakatsanis noted that intrusions of law enforcement into privacy must be reasonable. There must be safeguards to prevent abuse. And there has to be this appropriate balance between privacy and the public interest in law enforcement activities. Most recently, this concept was highlighted by an Ontario court decision dealing with Rogers and Telus that recognized law enforcement activities can take place, but there have to be parameters and there has to be respect for charter rights. So let me turn now to the activities of my office, and I want to talk about what we view as 4 success stories, and then touch on 4 current activities that we have ongoing that we've been involved in. The first one I want to touch on in terms of success stories is the area of police records checks. Our office has been involved over the years in the issue of police records checks. Generally, it is a case, our involvement has been when people have come to us and complained that a record check that was conducted was overly broad and involved information that was irrelevant to the purpose of the record check, and particularly non-conviction or mental health information. We were pleased that the Ontario Association of Chiefs of Police picked up on this issue, involved our office in discussions on how to approach this, as well as other offices, and in 2014 released guidelines on the conduct of police records checks by police services. And part of the purpose of those guidelines was to regulate the scope of the check and ensure that only information relevant to the purpose of that check was included. You will know that the government introduced Bill 113 last year in order to build on the OACP guidelines and to bring some consistency to this area. The OACP guidelines were guidelines only. They weren't mandatory. And there still was a range of inconsistent activity in terms of how records checks were being conducted. So our office was very pleased to have been involved in this, and the fact that the government and the ministry picked up the challenge and introduced legislation. The bill is very specific about what kinds of records checks can be conducted, and as importantly, is very clear as to the types of information that can be included in each type of check. And we were very pleased that non-conviction information is strictly regulated and is only involved in a vulnerable sector check, a very small window where this type of information would be disclosable. So I think this is a really good example of where the legitimate needs of organizations to have records checks conducted has been accommodated in a manner that does respect the privacy of the individuals involved. Our office has also been involved over the years in automated license plate recognition systems. We got first involved in this back in the early 2000s when the Toronto Police Service introduced a license plate recognition program This is a program that would collect randomly license plates in a parking lot or along a street, check that plate number against a hot list, which would include stolen vehicles, individuals whose license may have been suspended, or expired plates, that type of thing. And if there was a hit, then action could be taken. We went in and did a review of the Toronto police system and found that they were putting it into place in a manner that was consistent with privacy legislation. But we did pay particular attention to the purpose that they were putting this information to, and became satisfied that the collection of license plate information, which can be very quickly associated to an individual, was only being used to see if there was a hit on the hot list, and was not being used for other secondary purposes. Of particular importance to us was that non-hit information, which would be the majority of the license plates that would be scanned, the license plate information was only being retained for a very, very minimal period of time. And that was our main concern, that a person whose license plate was not on the hit list, as it were, was innocent, and that license plate information should not be retained. And we are satisfied that the Toronto Police were keeping that for a very minimal period of time. We've also been involved with the Ontario Provincial Police. They've approached us on a number of occasions about their program, and they have what we consider to be a very good governance framework in place that spells out very clearly the purpose of the program and how personal information collected through that program is going to be used, and more importantly, how it's not going to be used. Paying particular attention to the limited retention time for this information. A third program that we view as a real success, where we were able to manage this, the needs of law enforcement and privacy protection, has to do with programs provided to victims of crime. One of the core mandates of police services is to provide services to victims of crime. In fact, that's spelled out in legislation. That service is often provided through a community agency, a victim services organization. Those organizations were finding it an impediment to their provision of services that they did not have contact information about victims. And the programs generally were being operated on a consent basis. In other words, if a victim needed to provide their consent for the victim service organization to contact them. And victim service organizations came forward and said, look, this is a problem. If we only had very minimal contact information on victims, we could approach them and we could offer our services, and we believe that there would be a greater pickup in the work we're providing. Again, we worked with the Ontario Association of Chiefs of Police on this. We recognized that the goal here was laudable. That was to ensure that victims of crime were aware of the services that were available. And through that work with the OACP, we developed an agency template agreement which spelled out that the Victim Services Organization would be acting as an agent for the police service. And that template agreement was very clear in terms of the limited amount of information that would be provided to victim service organizations and how they would use that information. We are satisfied that the goal of providing greater services to victims could be achieved with a minimal amount of information being provided, and having a template in place that spelled out the framework for the provision of that information. In December, a couple of months ago, the Ministry of Community Service and Correctional Services accepted this template agreement as a way to move forward in this area, and to our delight, sent out an all-chiefs memorandum encouraging the OPP and provincial municipal services to use the template as they went forward in providing victim services. So again, we view this as a real success story. The final one I want to touch on, and this is one that I'm very proud of, had to do with the flow of information between organizations who may be involved in children's services, providing information to children's aid societies. We were approached a while ago by the Provincial Advocate for Children and Youth, and from his experience and information they were receiving from coroner's inquests, there seemed to be a lack of clarity as to the occasions when organizations involving youth could pass information on to children's aid services when they had a legitimate concern about the welfare of young people. And often the reason given for not providing information to children's aid services was, well, we have privacy legislation in place that prevents us from doing that. The provincial advocate came to our office to say, is this true? Are police or schools or public health organizations prevented from sharing information with children's aid societies when they have a legitimate concern about the welfare of a child? We looked at the law and we were satisfied that there was nothing in our legislation or in the Child and Family Services Act that prevented this flow of information. In fact, in some cases, it's mandated, it's required. So along with that office, we put out last week, put out a publication. It's a small little brochure that can fit into people's pockets, aimed at those organizations that are providing services to children, teachers, police, health organizations, to make it clear that if they have a legitimate concern about the welfare of a child, they have the ability and in some cases the requirement to communicate with children's aid societies. I'm especially pleased with this that we were able to cooperate with another office of the legislature, the Provincial Advocate for Children and Youth, to put out something that I believe is aimed at the goodwill of the citizens of the province, particularly vulnerable area like children. So those are 4 success stories, and where I believe a collaborative effort in bringing goodwill to the table has seen some really good results in some important areas. In the remaining time, I just want to touch on some of the ongoing work that we have, and some of these issues you're going to hear about from our panelists. The first one has to do with an issue that was in the media about a year ago, involving the disclosure of information via CPIC to American Border Services. There were a series of newspaper articles that came out where people from Ontario were stopped at the U.S. border, and it became clear that the agents at the U.S. border had information about these people, specifically that there had been an incident of attempted suicide in the past. I think most people felt that this was inappropriate, that if someone had attempted suicide in the past, this was really irrelevant to their ability to enter into the United States. Our office opened an investigation into this, and what we found was that on occasion, police services were uploading attempted suicide instances onto CPIC, the Canadian Police Information Centre database, which is the criminal law database for the Canada, and that that information was residing on CPIC, and incidentally, the U.S. border through Homeland Security had access to that database. And what we found was that individuals would pull up to the border, the U.S. border guard would have access to the CPIC database and would see that this individual had an incident of attempted suicide in their past. As a result of our investigation, we came to the conclusion that the automatic uploading of attempted suicide to CPIC was not in accordance with our privacy legislation. And what we did was put out a report called Crossing the Line with a number of recommendations. First, we said that police services should cease the automatic uploading of attempted suicide incidences onto CPIC, and that while there may be occasions where that information could be legitimately placed on CPIC, there needed to be discretion exercised in doing that. We put out what we call the mental health disclosure test that set out the circumstances where we felt it was appropriate for that information to be placed on CPIC. For example, if an individual had a history of violence, or if the suicide attempt involved a threat of safety to other people. Now, as a result of that, and why this is still an ongoing issue, we found that during the course of our investigation, we found that Toronto Police Services were one of those police services that was automatically uploading to CPIC. And as a result of that report, we had some discussions with them to get some assurance that they would be following our recommendations, and did not get that assurance. The police indicated that Toronto Police indicated they would continue to upload that information automatically. As a result of that, we did commence a court application challenging that position that they would not exercise discretion. The good news on this, though, is that the Toronto Police, as a result of our report, worked with CPIC officials and developed a system that could suppress information, the attempted suicide information that was placed on CPIC, suppress that information from going to Homeland Security and therefore to the border. So this problem of innocent people arriving at the border and having this past incident brought to the attention of the border guard, there was a solution to that. So we were very pleased with that. That has resolved a major portion of the issue that we had when we released the Crossing the Line report. And we're very confident that we're going to be able to resolve this court case amicably and in a manner that serves both our purposes. So stay tuned on that front. The second issue I wanted to touch on that's ongoing, and I know you will hear about this from our panel, is the area of police street checks. We have been working in our office with the Toronto Police Service and their PACER committee on this issue to try to bring some regulation for when street checks are conducted. We were very pleased that the government and the Ministry of Community Service and Community Safety and Correctional Services picked up on this issue and decided to bring some provincial-wide guidance on street checks. We've been involved in detailed discussion with the ministry on the issue. They released a draft regulation that we have provided our feedback on, and not just our office, but the Ontario Human Rights Commission and other civil society organizations have also weighed in on the draft regulation. We really do commend the ministry for taking leadership in this area to bring some regulation. We have provided recommendations on where we think the draft regulation can be improved. For example, including a broader range of encounters with police, including the investigation of specific offenses. We've provided some recommendations to enhance the notice that is given to individuals who may be subject to a street check, and also some improvements that we view are necessary in the area of data retention, particularly legacy data, information that may have been collected that is acknowledged to have been in violation of the Charter in the past. How is that information going to be dealt with going forward? So we're very confident that first of all, we're very pleased that the ministry has involved us and other civil society in this discussion, and we're confident that this issue can be resolved. The third area to talk about that's ongoing is the subject of body-worn cameras. The Toronto Police Service has implemented a pilot project with body-worn cameras. That comes out of a recommendation from a report provided to them by the former Chief Justice of the Supreme Court of Canada, Justice Iacobucci, where he recommended that the Toronto Police engage in a body-worn camera pilot project. I think there's a recognition, a pretty broad recognition, that body-worn cameras have a role to play in terms of law enforcement and in terms of enhancing accountability and transparency, both on behalf of police officers but also the public. But body-worn cameras do present some interesting issues from a privacy perspective. They will be collecting potentially a lot of information about citizens who are going about their activities, everyday activities, in a law-abiding fashion. They're also mobiles. They're not like a fixed camera at an intersection or on a building. The mobility means they can collect even more information, and they also can go into areas that, that may have a heightened sense of privacy, like an individual's home, hospital, place of worship. So we did work with the Toronto Police Service prior to the body-worn camera pilot project going into effect to address these issues and ensure that the benefits of body-worn cameras in terms of transparency and accountability can be experienced while recognizing legitimate rights of privacy by individuals whose images may be captured. So we did work with them in terms of, and impressed on them, and we would impress on any other police service going this route, that there really needs to be a lot of thinking going into a governance framework for how body-worn cameras are going to operate. For example, when are the cameras going to be turned off and on? It's very important that a protocol be put in place so it's very clear that if the cameras are not going to be operating on a 24-hour basis, that an officer knows when he or she needs to turn the camera on. Really important issues as well around the use of the information. It's important to ensure that they're strictly used for legitimate law enforcement purposes, and that function creep does not enter into how those images are going to be captured. Security of the images is also vital. A need to ensure that the images are secure, that access to those images is limited to only those people who have a legitimate right to it. So these are things that we're satisfied the Toronto Police paid attention to in terms of their pilot project. We're looking forward to the results of that. My impression is that other police services in the province have been careful about going down this route. They recognize the importance of addressing privacy, and as I say, we look forward to the results of the Toronto pilot, not only in terms of their usefulness, but in terms of the kinds of protections that we've seen them put in place. The final issue I want to touch on is what are called situation tables or hubs, depending on what part of the country you're from. These are projects that have been put in place primarily in Saskatchewan and Ontario. They're designed to bring resources and services to people who are an immediate risk of harm to themselves or to others. And generally how these function is that organizations in the community, police, education, public health, social organizations, get together as a group to discuss individuals who may need their services, identify which services may be required, and then to offer those services to the individual who's at this immediate risk. There are some clear issues that are raised by this in terms of the collection of information, collection of personal information. We're dealing in many cases with very sensitive information. Quite often, this activity will take place without the consent of the individual. In other words, there will be a discussion about an individual's needs and vulnerabilities without them being aware of it. So this is happening without consent. And this raises issues around governance structure, training, and ensuring that everybody is playing by the same rules when they're disclosing information about a vulnerable individual. Privacy commissioners have been involved in this area over the last couple of years. The Saskatchewan Commissioner, Information and Privacy Commissioner, released a report in November. Our office got involved in a big way in 2015 at the invitation of Matt Turgeon, the Deputy Minister. I attended a meeting in Ottawa of law enforcement officials in January. Our staff have sat in on hub meetings to see how these are operating on the ground, and as a result of that, have been able to provide what we feel is guidance on how these can operate in a manner that brings services to vulnerable individuals, but in a way that respects their privacy and limits the disclosure of their information to a need-to-know basis. We've developed a harm prevention disclosure framework that we think gets the balance right, that allows information to be disclosed on a need-to-know basis, but not beyond that. We will continue to work with the ministry in this area. I think that the idea of a situation table is laudable. It's bringing services to the most vulnerable and people who really are at an elevated risk of harm. And I think that we can get to, through discussions and cooperation and goodwill, we can get to a model that respects their privacy in addition to bringing services to them. So we look forward to discussions not only with the ministry, but with police services around the province. That's my quick review of the activity of my office in this area. If there are any lessons that I think I've learned is that it's really important for us as an agency to have an open door. We want to work cooperatively with the law enforcement community. We realize that they do really important work. We also, from our work, know that there's a real recognition of the importance of privacy. And I've seen a collaborative spirit develop with the agencies in the province. I think we've gotten to some really good solutions that has appropriate privacy protections in place while allowing law enforcement to go about their important work. And we look forward to continuing with that in the future. Those are my comments. Before we get to the panel, I do have a few minutes for questions if anyone has them. There are microphones set up on the floor. Is there any questions? Okay, well, if not, we will take a break. We're going to get our panelists together and get them ready, and we are coming back. I think we're scheduled to come back at 10 o'clock. So those on webcast, we're going to take a quick break, and we'll see you back at 10. Thank you.